Hello, everyone. It's so nice to have you all here. Today, we will talk about balancing data protection and workplace justice, how GDPR can help us enforce the employment rights and representation. Of course, the topic is very relevant because now we have the managerial system in almost all of the fields, and regulating the data in workplace is more than regulating just data, it's about regulating working conditions. That's why this topic is very dear to us, because we want to interrogate how the GDPR can help the workers outbalance the situation, like the surveillance and all the measures taken, and how it can also enhance the atomization, like not enhance, of course, but be a measure against the atomization in work and enhance more like public goods, common goods, and individual goods. And today we have great speakers. I would like to introduce them first. We have Nikos Papadopoulos from Homo Digitalis, and Homo Digitalis is an NGO based in Greece. He is also an associate at Ballas Pelekanos, the law firm, specializing in data protection, technology, media, and telecommunications. He did his LLM in Leiden University in Law and Technology. He's an active member of Lexing Advanced Technology Law Network. And if that's not enough, he's also a member of the Athens Lawyers Trade Union. And we have Larisa Munteanu. Yes, I did. She's doing her PhD in Erasmus School of Law. She started her career in the UK as a data protection officer and data protection lawyer. Then she established her own business called Protector Privet. And she specialized now she's writing her thesis on data protection requests in malware attacks. And she's specialized in cybercrimes, AI, global data protection regulations. And in 2022, she won Best International Future Lawyer Award, which I want to underline. And we have Eva King. She's from Arbeiterkammer Vorarlberg, Austria, the Work Council. She's an economist. We are glad to have also an economist here. And she's EU representative of the Austrian Chamber of Labor. She had been in many key roles, Director General of the Chamber in Vorarlberg, positions in Austrian National Bank, European Commission, Managing Director of the US Financial Service Provider, and she holds also, she's now currently doing her LLM in AI and ICT law in KU Leuven, and actively contributing to shape labor policies and economic frameworks in Austria and in the EU. And we have Aída Ponce del Castillo. She's from ETUI, and she's a qualified lawyer, has a master's degree in bioethics, and has also her PhD in law. Her research focuses on cross-boundary field between science and emerging technologies, especially with a particular focus on AI. She's a member committee for the National Convergence Plan for the Development of AI in Belgium. At the OECD, she's a member of the working parties on biotechnology, nanotechnology, and also she worked as a coordinator of the Workers' Interest Group at the Advisory Committee of Safety and Health of the European Commission. So finally, I'm moderating today. I'm a postdoc researcher at KU Leuven, CiTIP Center for IT and IP Law, and my research focuses on rather risk assessment in criminal justice, but I'm very happy to chair this panel because, as I said, this topic is very dear to us, and I'm a licensed lawyer also from Istanbul Bar Association and have been teaching criminal law and procedures in several universities. So I'm happy to start, not to take more of your time. As we have promised, today we will talk about how GDPR contributes to workers' data rights in the workplace. So let's start with this question. Really, how does GDPR contribute to the data in workplace, and what has been the impact of GDPR on litigation? Of course, we are going to talk about collective enforcement later, but as a general question, maybe I can start with Eva.
Hello, and thank you for inviting me to this panel. I'm speaking more from a practitioner perspective because in Austria our organization represents all working people. That's 3.5 million workers. And the reality that we see is that we have a strong deployment of AI tools, but algorithmic management tools, data processing in the workplace. And we have GDPR now over 7 years. And in principle, we have Article 25 that says there should be data protection, data privacy by design and default. What we actually see is a lot of infringement and very little enforcement. And the question we asked ourselves together with some other institutions is, what is the reason that there's so little enforcement? And I don't know if anybody here in the audience knows how many DPA complaints were there related to workplace. Any idea in your country at least how many workplace-related complaints the DPAs have been processing, following up, deciding on? Or how many court cases that were sort of in an employment context, GDPR-related? I think nobody has this data. That's exactly what made us commission a study, and I was involved in the study design, and it's still ongoing. And so what I will be talking about a little bit about this individual enforcement and collective enforcement is trying to gather for 10 countries in the EU the empirical picture, how many claims there were, how many decisions were made by the DPAs, and what is really the level of enforcement. And so what we've been looking at, to start with the individual enforcement, is individuals, data subjects, workers, have in principle several routes that they could follow. One is they could go themselves and complain to the DPA, Article 77. They could also go directly to court and sue a processor or a data controller, Article 79. And they could also, of course, act against the DPA's decision, which is Article 78. But they don't only have these individual rights to enforcement, they also could mandate an organization, a specialized non-profit organization, to follow up on their claim, to represent them, which is Article 80, paragraph 1. They would also, the GDPR would also foresee a collective dimension with Article 80, paragraph 2, which I can take that already now, but has not been implemented by any country. So if we just look at this individual dimension of how many workers have really complained or gone to court about infringement of their data rights. And the picture is very bleak. In fact, we have below 50 complaints in almost all countries that we looked at. Spain is the exception. But then even when we kind of try to gather this picture, it becomes apparent that none of the DPAs publish actually all their decisions. They don't publish it in a structured way. They change the methodology, like in France, so it's very difficult to ascertain really what is happening. So it's very intransparent of how many claims they process. We know by those decisions that have been published that DPAs are very slow, and they're the real bottleneck in enforcement. So in Austria, for instance, the time is 3 to 4 years to process a complaint, and they've done below 50. And when we see and we look at the agenda of the DPAs across Europe, and you know the Central Data Protection Supervisory Board in the EU publishes also kind of the agenda. Work-related data protection is very low on the agenda, and we see that in actual enforcement action. I mean, the lowest, if I was sort of talking now the best in case, it would be sort of looking at Germany, that's got sort of an active DPA approach, Italy and Spain and France. And the bottom of the class is Luxembourg, not surprisingly, and also Ireland, where most of the large, digital enterprises are incorporated and have their headquarters. And not only that, in fact, they have really been criticized even by the High Court in Ireland, for instance, for the handling of data protection claims. There's only 9 law cases or sort of employment-related lawsuits of individuals. So there's very little litigation action. And what we have tried to understand is it also maybe because that individuals are not aware of the rights, or the procedural hurdles are too high, or the incentives are missing, because if you want to have actually damages awarded, you have to go into a civil kind of court in order to ask for the damages. And the fines, and that is the other kind of shocking thing, the fines that have been in fact awarded for assigned for data protection claims, they're very low. I mean, we're talking about a couple of €1,000. That is the case, I mean, in most DPAs. And what's been worse is where there were actually high fines considered. Like take the case of Germany, when there was a huge complaint about Zalando's performance management tools. They had to be pushed to even follow up on that complaint when they actually found huge infringement on the case of Zalando. They did a private guidance to Zalando to coach them into kind of changing their procedures rather than fine them. And that is also what we see, is that there's very few fines, or if, then they're kind of handled on an administrative level, so they're settled somewhere. So there's hardly a deterring effect. And even if they're high fines, and we only see high fines in the case of France and the Netherlands, where there were a lot of very high-profile platform workers cases. So the biggest lawsuit was 170 Uber drivers that sued Uber in the Netherlands. It originally brought the case in France, but that was 290 million. But the fact is, that's not final, because all these decisions are being appealed, so the actual fines the companies are paying are much lower. So the real deterrent is not there. So the fines are not a significant deterrent. So that's what really we see on an individual level, and I'm sure we'll talk about the collective dimension later.
Yeah. And Aída, do you have also some remarks on the impact of the GDPR in the workplace, just as a starter, or?
Right. As a starter, I have to say that the GDPR does have an impact at the workplace, but for that we need to understand the context of employment. And workers are working in a symmetry power where they have to be bound to an employment contract and then produce work. From the work they are getting retributed by money. And here, for many, many years, we know that the asymmetry of power and asymmetry of information communication has always impacted how workers exercise their rights, not only labor rights, not only social rights, but when it comes to this third generation of rights, which are very new to the workplace, which are not part of the social labor package because they come through data protection privacy dimension, then exercising those rights become more difficult. So at the workplace, we have this new idea of having new rights, but when it comes really to having an access request or the right to object to the employer, sorry, I don't want you to object. I want to object to this processing of my data. I don't think it's really, really easy to just go through the employer, because there is always this risk of, you don't want it, well, you can just go. There are different types of workplaces, the more precarious ones where we see, for example, workers in Amazon warehouses, which are very active, but still with a very different level of power asymmetry, because they cannot just talk to a manager, because there is no manager. There is just algorithmic management inputting what that worker should do next. We have other less precarious workers, but in which the power asymmetry is always equally very high in big companies, multinational companies, where most of the privacy or AI and data governance policies are not crafted in the EU by the national laws, but they are crafted in other jurisdictions, and they're just imposed. So when it comes to, for example, negotiating DPIAs, because new technology is being rolled out in lots of plants in Europe, in an automotive company, in a food company, many, many multinationals, when we see the DPIAs, they are there, but they are empty, or less not really that described. So we have to push a lot in negotiating to have really DPIAs in which workers can just see, observe, and maybe negotiate at the Works Council level, a very high level, meaning the European Works Council. So whether you have a company which pays higher wages or a company which is perhaps less precarious, you have exactly the same asymmetries of power, information, and the prerogative of the employers. Trade unions are part of this ecosystem. And they have a role. They always have had a role in defending workers' rights collectively at the workplace. The trade unions use a lot of labor law, national law, and social law, equally national at the EU level. And they do have a lot of experience in representing workers within a lot of labor issues, pensions, violence, discrimination, etc. this new legislation, which is GDPR, or let's say new ways of regulating privacy at the national level, it's also new for them because they are not being so much exposed into defending workers' rights collectively into the workplace. But just to contrast what Eva just said, we do have the actions of the DPAs. And I had the opportunity to talk to the CNIL last month, and they did reveal that 30% of their phone complaints, because they do have the capacity to have a call center, are workplace related. So that gives, they're already starting to think, okay, what's going on? The other side is that we do have some evidence that there are huge violations. Why? Despite the case that there are not so many investigations being carried out, there are lots of significant fines. And they are very significant. Amazon, Uber, H&M, and other smaller companies, they are being fined because of worker-related issues. So my positive message here is that DPAs are not labor lawyers, are not the labor inspectorate, but they are observing that there are violations to digital rights to the workplace, and they have to start keeping that machine saying, okay, we need to do something. And hence, they are starting to issue not only fines, whether they are smaller or higher, depending on the case, of course, but they are also issuing national level recommendations basically to employers on how to process workplace data. And with that, I'll give the floor back to you.
I see some similarities in what you said, in both of you, what you said, because in one way you underlined that the individual character of asking for rights might be very difficult and challenging in an asymmetrical power situation, and hence there may be few claims against the workplace happenings towards DPAs. But how about another option that GDPR foresees, collective right enforcement? Is it working, and what are your observations on this right? Are people using it, and is it effective? I'm again coming back to you.
Yeah, I'm very happy to start off. I was just wanting to add something to what Aída said, because it's quite interesting to see what's working well. What's working well is when the DPA takes an active interest in what's happening at the workplace. And we've seen the positive sides of DPAs in Italy, as I said, in Spain, also in France, where, because the DPAs have a right to do ex officio investigations. And in those cases, the really high profile cases were also kind of constructed in a collaborative effort, mostly platform workers, unions, working together with the DPAs to do actually these investigations, because to bring high-profile cases, you need a lot of evidence. And that is already one of the issues that I'll hint at when we conclude this panel, which is really what's missing is even to bring a good case at the DPA, you need evidence. And evidence gathering means that most claims are based on right to information, so Articles 13 to 15, in order to substantiate claims. And that is also when unions get involved and active. It's also actually what we've seen often, because they use the GDPR rights to substantiate claims in labor law, in lawsuits, for dismissal, for instance, and to get a higher compensation. But they're not so much used kind of in its own right as really kind of protecting the data of the workers. And that's really what is interesting. And now this is already bringing me kind of to the collective dimension. I said before, the collective dimension would mean that not you, me as an individual, we go and complain or we sue our employers or controllers for what they do with our data, which we know said hardly anybody really is aware of what's happening with your data. I guess that's the case for you if you're working as well. But the problem is, or let's say the collective dimension would mean I could mandate an organization, or that could be a trade union, that could be a consumer organization if it was a consumer claim, but we're looking here at labor claims. And so the problem is the GDPR foresaw that collective dimension in this Article 80 that I mentioned, but what we found is that Article 80, paragraph 2, that means own initiative claims. So that means if I'm a specialized organization like our organization is, that has a lot of knowledge about this, we can't get active without a mandate. And it's very difficult to find individual employees, and that's what our lawyers are telling me as well, is to find individuals that want to sue their employer in an active employment relationship. That's a major problem, and I think you hinted at that when you said there's a power imbalance. And it's not only the power imbalance, the problem is I don't do that if I want to maintain that relationship. And so most claims have been brought in platform work, where it's a very transient or not even an employment relationship. By the way, that's the one political success this has brought so far, the litigation efforts, is that the courts are changing the way that the platform workers are seen. So we've seen in France and Spain that platform workers, in the Glovo case, for instance, the platform workers are considered now employees and not self-employed, and that's key. That's the same for other key cases. So that's what suing can bring. But so there's very little. As said, so Article 82 has not been implemented. Paragraph 2, Article 80, paragraph 2 to be correct. So own initiative complaints cannot be done in any of the countries. Second point, Article 80, paragraph 1, that means where I need to ask you to give me a mandate to represent you. In many cases, the unions have been either explicitly excluded by the legislature when in the or considered to be excluded, like in Germany, they're not considered to be eligible. The European Court of Justice has only passed one decision on this, which confirms that only consumer protection organizations are entitled, and has not ruled yet on unions. But we see very few countries where actually unions are entitled to go to complain. And even where they're entitled, there's very few action. So basically, you could say very little union action so far in this space on the collective dimension. What we looked at was going a bit beyond it, because we don't only have the collective dimension, as said, through the GDPR, but like Aída said, labor rights in many countries already give unions and works council the right to act on a collective level. That means to access information about the systems that are being deployed, to co-determine the systems, like algorithmic management systems that are being deployed in the workplace. So they have these rights through labor laws. So we looked at that as well. And you do see quite a lot of union activity, certainly in countries with a longer or stronger union tradition. That means they have collective agreements on CCTV footage use, or on GPS tracking, or on surveillance in the workplace. So they have passed collective agreements that are then binding for the sector or whatever the union kind of represents. And there's some union interest, but as I said, it varies from the places with strong union tradition to the places with less union tradition. And the other collective dimension that we looked at is there's the EU collective redress directive. So we were interested to see if there's other maybe avenues that open up for class action, like, everybody knows Max Schrems. So we were curious to see, could strategic litigation be an option to stop some of what is happening, which could have quite a broadband effect. And again, the picture is not as clear-cut as one thinks. This is the EU, and so it works everywhere, and it's everywhere going to be the same. But very few countries actually permit to bring mass action related to data protection claims and make, therefore, this jurisdiction an interesting place to do strategic litigation. One such place would be Ireland because of the organization's headquartered there. The other one is the Netherlands. But as said, for instance, in Germany and other places, it wouldn't be permitted, or in Poland, you can't bring, they have mass action, but not for data protection claims.
Thank you. Does any of you have any remarks, or shall I? Okay.
I would like to make one small remark about what was talked in terms of litigation. In my experience now lately, in particular, I noticed a trend in how the data subject access requests are used as a litigation tool. And this is in particular in the area of employment. And in this sense, I also gathered the knowledge that law firms are now instructing employees, especially in cases of unfair dismissals, maybe to go back to the employer, sometimes with the purpose of gathering information for the potential lawsuit that will come, or sometimes simply to just cause some harm and disruption at the employer. And I think this is borderline to become an abusive practice, or maybe a practice that should be better limited also at the regulatory level. Of course, the data controller has the option to reject the request if it's manifestly unfounded or excessive, but I would say it's very, very difficult to make a case and to justify such a decision in a case of unfair dismissal and in the bigger picture.
Now I will turn the subject around towards the trade unions, because when we think of the data protection, we always think of it as enhancing workers' rights, but at the same time, it also foresees some obligations for the trade unions to process workers' data. And having also talked to some of the unions, I realized that they are overdoing the implementation, sometimes fearing that the governments might impose them fines. So it even prevents them sometimes accessing to workers to, show themselves, introduce themselves, and many difficulties are raising up as a result of these obligations. And it's hard to balance these obligations and thinking of labor rights terms. And do you see any implications of GDPR for the trade unions, and what kind of difficulties they might be facing in practice? Maybe I start with you, Nikos.
Hello, everyone. Let me first give you a kind of idea of what is the Athens Lawyers Trade Union, because it will be helpful down the road. We founded this trade union back in 2020, and our goal is to represent lawyers working under employment, not being self-employed. And until 2020, we were all together represented by the Bar Association. So, in a way, we wanted to start the discussion on collective bargaining with our employers, who happen to be also lawyers. Let's start with the unique obligation for trade unions. In 2021, there was a law enacted in Greece that founded the General Registry for Trade Unions. And based on this legislation, all trade unions must register with this specific registry and submit specific information. What kind of information? The trade union's statute, information about the union like the name, the establishment, etc., but also the number of members who voted and the number of members who had the right to vote in the latest General Assembly, and also financial information such as the members' fees, donations, sponsorship, the minutes of the sorting of ballot papers, whether the voting was done in person or via electronic means, which members were elected, which members participated in any way in the voting, etc. If that information was not submitted to the registry, the trade unions faced specific repercussions. They could not participate in negotiations for collective bargaining with the unions of the employers. They could not use the protective provisions of the Greek employment legislation regarding dismissal of elected members or relocations, and they could not use the provisions that allowed elected members of the trade unions to reach out to their colleagues inside the workplace. And it is important to state that not only the General Secretariat of Employment of the Ministry of Employment had access to this registry, but also single employers who could simply demonstrate their legitimate interest could have access to this registry. And also, it's funnily enough, there was not a single provision regarding data protection on this legislation or in the subsequent ministerial decisions. there was only a proclamation that all data protection legislation should be respected and that technical and organizational measures shall be taken, but nothing concrete about that. So then the trade unions faced a dilemma. Either they should register in order to have the protective provisions on their side, or they should do something about it. And we decided that we will do something. So at first, most trade unions decided that they will not register, and we had strikes, demonstrations, etc. But also we took legal action before the Council of State, the Supreme Administrative Court of Greece, and the Council of State examined the provisions, and they found out that not only the information required were personal data and specifically special categories like the membership of trade unions data, and also they understood that the legal basis for the processing of such personal data could not be found in Article 9, because this was not a processing in connection with the purposes of the trade union, but the personal data were disclosed outside that body to different parties without the consent of the data subjects. And it could not found a consent freely given in this dynamic of powers in that case.
Thank you very much. And Larisa, do you have also some remarks?
Yeah, I would like to point out several things here. To add to what Nikos said, indeed, in the GDPR, we won't find much specific to trade unions. So the trade union membership data, of course, is labeled as a special category of personal data that we know, and therefore requires stronger security measures, so technical and organizational measures in place. However, this is very broad, and I'm saying it's very broad because the way we process the special categories of personal data works for both employers and trade unions. So both of them would, in specific circumstances, process these special categories of personal data. However, what I found very interesting is that there is no definition of what trade union membership data means. Nowhere in the GDPR, maybe in some other external sources, but not directly linked to the GDPR. So I actually prepared an article which was published a few years ago, in which I'm attempting to create a definition for this. And I think there's one decision which is from the UK, quite an old one from 1995, that is explaining that perhaps we should have a more extensive definition for trade union membership data. And what that means is we shouldn't only look at, is this person a member, yes or no, or which trade union is he or her a member of. We should also look at the activity of being part of a trade union. And in that case, it was actually very interesting to see that it was an unfair dismissal. And the employee in the case sued the employer, saying he or she was discriminated because of their activities as part of the trade union, whereas the law prohibited dismissal in terms of membership to the trade union. So the employer said, oh, sorry, the law just says discrimination against my trade union membership or your trade union membership or your status, not your activities. And indeed, I fired you because of your activities. And therefore, the court said we should look at it, we should interpret it extensively. And I think this should also happen with the GDPR in order to look at the spirit of the law. Because there may be many employers that take advantage of the fact that the definition is nowhere to be found, and therefore would just say, yeah, this is special category, but whatever is more than that is not a special category, so I can just juggle a bit with less safeguards, perhaps.
I just wanted to add to that. I find it quite worrying that it's not only there is no definition, the fact is that we have a lot of cases where there's been actually spying on trade union activity and workers' organization by the employers. There's a prominent case in Austria against OMV, that's the main energy producer, for exactly that, spying on the Works Council. And we know from various trade unions, that sort of from informal feedback, that communication data is supervised of people that are being suspected to be friendly with the unions, where there is no council, or they could be creating a works council, etc. So there's, in fact, quite a strong set of indications that employers are using the tools also to find out if there's union activity or if there's intention to create a union. So it is a very important, it's very relevant what you said, that we not only have a definition, but again, it's all about the enforcement.
So then I continue with the next question asking, is there any legal basis to justify employers' knowledge on the union membership or union activities in the GDPR? Maybe coming back to you also, what would be the legitimate interest to learn all this information about the voting, who voted for the, like, do you see any legal basis?
No. But no, to be serious, I don't see a legal basis on Article 9 for this specific use of personal data based on the legislation about the registry for trade unions. But there are specific examples where the employer should be able to process specific data and special categories like membership situation. For example, because the law provides special protection for elected members, the employer should know that this employee is protected and should not be dismissed, should not be relocated, that they have the opportunity to reach out to colleagues in the workplace regarding the purposes of the trade union. So there are those concrete examples, but I think that there needs to be in place some kind of limitation of these examples. Because, for example, let's see what happens in strikes. Although there's no need for the employer to actively process data about the membership of the employee who participates in the strike, there are specific examples where the employer provides a specific leeway to collect those kind of information. For example, we have this human resources platform, and you need to provide this information about your participation in the strike. And there's always the explanation that participation in the strike, it's not actually information about your membership status, but in a way it is, especially when the participation in a strike it's low and only the members of a union may participate. So yeah, I think I opt for this limitation of specific examples.
Mm-hmm. And Larisa?
Yeah, I would also like to add something to it. So of course the rule is the prohibition of processing such data. I think on very limited cases the employer would rely on explicit consent. However, the trick there is exactly what Aída also said previously, the imbalance of power. So I would say most of the times in practice that consent wouldn't really be valid or wouldn't really stand. And what you also see in practice is the use of another legal ground of Article 9, which is the establishment or defense of legal claims. So if, for example, an employee is trying to sue the employer via the trade union, of course the employer would need to get access to the fact that that person is a trade union member. But again, as also you said, it needs to be super limited to what is really necessary for that purpose. So in reality, due to the nature of these two entities, employers and trade unions, should be very careful, very role-based controls in place, and yeah, very, very secure as well, very limited.
Thank you.
Right, but yeah, we have to remember that consent is not a valid legal basis to process workers' data, and it's true that another trend of many companies, especially big companies, is that they use consent to process not only trade union data, but other types of data, and that is just a trend that is being almost established, and there is very little awareness that the consent is not just, it cannot be used. There are the law or the authorities in Europe, the European Data Processor Supervisor and the Working Party 29, were very clear. Consent cannot be used, and if it's used, it's in a very exceptional circumstances. So I think that one thing that needs to be clear is that exception on the consent.
Mm-hmm. And while we are talking about consent is not a legal ground, how about workplace surveillance? And we talked about already Amazon, and in a way, as a work organization, when the workers are surveilled and on a quota-based system, and they are required to be speedier and speedier, it also concerns the work safety. And in California, where most of the Amazon workers are based, we see already some laws emerging, not in data protection way, but more in the safety regulations, that deciding these quotas should be declared to the workers, and they should have, in a way, consent for it. They should be aware of it, and unless they or their representatives cannot consent to it, they cannot proceed. But in any case, where should we draw the red line for the surveillance at the workplace is a major question we need to be asking ourselves, and I would like to have your opinions also from the floor.
Yeah, it's a very political question. It's not a legal question, I think. It's a normative question there is, of course, some legal remits, which should be, what are these legitimate grounds on which because that's the main law of grounds, on which you deploy all those tools. And what I have to say to that is that most of the tools already deployed, and such basic things as, I'm sure you're all using Office 365, or maybe your organizations use SAP, these tools are infringing GDPR rights. And you cannot actually, with whatever legitimate grounds, justify the use. And the point is, a lot of the data protection principles are infringed by the deployment of tools. There's no data minimization. There is no erasure. Basically, there is no purpose limitation. There is nothing such thing, and certainly there's no transparency. So neither you know what they're doing with your data and why they're using it, nor your representatives. And so we have a huge issue. And I simply miss, and that's a political question, I miss that our supervisors, our legislators, do nothing about it. Basically, it's illegal, but nobody's enforcing it. And the data protection authorities are very few that gave guidance on workplace-related data processing, that made it clear what that limit should be, what is allowed and what's not allowed, and why you need the unions involved and where they need to sign off. But that's, on the broad scale, that's not the case. And it's very unlikely, and that's why we said really talking politics, it's very unlikely that now, with this political climate that we are heading towards, that there will be an algorithmic management directive for anything. On the contrary, we'll have deregulation and simplification. So we will have to discuss that. Where is the limit? Because what I wanted to point out before when we talked about individual litigation is the reasons that people today complain and litigate are relatively old-fashioned tools, meaning, CCTV camera in the wrong places, maybe GPS tracking, etc. This is mostly outdated. There's no cases on AI tools. And I don't know if you know, but the Commission just published a huge study on algorithmic management, a huge survey across Europe and also the OECD, and they all confirm, the level of deployment of AI tools now in Europe across all countries and all kind of sectors is between 40 and 60% that at least deploy our tools. So we have these tools being deployed. Where's the legitimate grounds? Where's the consent? Where's the transparency? Where's the limitations? There is no guidance on it. So, and yes, we have the AI Act, and I hope that theoretically the AI Act also has some strong rules that forbid certain practices. But what we see on the ground in terms of screening, appraisal, performance management, I mean, even the fact that you say the US are propagating the sort of output performance goals by having people sign off on, oh yes, I really love if I can do 200 pieces a minute, yeah, instead of 100 pieces. Sure, I consent to that. I mean, that's totally unrealistic, and it goes in the absolute wrong direction, I think, politically, if we let that happen. I mean, that's absolutely algorithmic management, if you have. And so we will have to have a political discussion upcoming when we talk about the deregulation or the change of the GDPR and maybe the AI Act.
Yes, Aída.
Right. If I could have the one slide that I have in the PowerPoint, if the team could help me to display it. Yeah, thank you. So, well, I think that I think that there is a legal element to this distinction. And I have been working a lot in this distinction of precisely what is monitoring and what is surveillance. And I published a book chapter together with my co-author Michele Mollet from the University of Groningen, in which we delve into what is monitoring, what's surveillance. And indeed, surveillance is defined. It's very well defined, and we have surveillance studies, we have sociology, we have anthropology, and we have labor law. Labor law defines monitoring. It does not define surveillance. And labor law doesn't have a word for that. And on top of that, many jurisdictions in the world use surveillance and monitoring as a synonym. So we have mapped all of these terminologies. But we have concluded that there is a distinction between legal monitoring, which is the prerogative that the employer has just because there is an employment contract. And because there is an employment contract and you're receiving the money, I have, as an employer, the prerogative to see whether you're working 8 hours, whether you're doing your job, whether you come to the office at time, working time, and that the job is done, so that the worker can receive a payment. So that's the boundary of monitoring, whether it's proportionate to the employment contract and necessary to do the job. Now, surveillance is not proportional, it's not necessary, and it has had other definitions that we have extracted from from Foucault, from Marx, from Susanna Zuboff. All these scholars have defined surveillance, and we know that surveillance is intrusive because it goes beyond what is proportionate and necessary. It is intrusive because it can go beyond the mere sphere or dimension of the worker persona, but goes into the intimacy. It is invisible because, as Eva said, we don't see it anymore. Before we could see the cameras or the clock ticking in the factories, but now we have the AI systems embedded in a convergent manner to monitor, to look at, I don't know what, can be a keystroke, a biometric, an emotion, a physical state, and behavioral state, all sorts of biometric and non-biometric features and signs. And it's non-material as well. We cannot touch. At the least, we have a screen. And again, it's illegal. And why do we know that surveillance is illegal? Because we have had decisions from the European Court of Justice and the Human Rights specifically drawing the line between what is monitoring and what is surveillance. And again, the decisions and fines from the DPA saying this is not lawful. This monitoring is not right, hence it's illlawful, and you have to pay a fine or just redo your processing monitoring. Well, so what do we propose is that employers need to be bound to the principles of proportionality and necessity, where really the prerogative of monitoring stems. And beyond that, this is when it turns to surveillance. Concretely, it will be ideal that all labor laws at national level will have to have this distinction palpable in their fingertips to say, okay, we need now to employ two different terms because it's not the same and we cannot treat them in the same manner, and slowly draw this difference really clearly in law, but already in practice and in other disciplines, it's already there. This is what I have to say.
Thank you very much. And Larisa, since you're also working on cybersecurity, also, do you see some correlation of this question to your work?
Yeah, definitely. And I encountered a lot of times clients coming to me and asking about how to implement different tools, which of course are focused on monitoring at the end of the day, or perhaps even surveillance, as Aída pointed out. I think that both monitoring and surveillance are really everywhere. So in this age, it's impossible to live really without any interference of them, just as when we walk on the streets and CCTV already recording us in many places. Even about this, I have a story that I was a guest lecturer to master's students that had a program on surveillance. And I was very curious. My first question to them was, did you notice all the CCTV cameras on the streets? Are you bothered by it? And most of them said no, completely unbothered. So I was shocked by it because, of course, I'm specialized in this field, but the new generations may not be that interested. And that comes from many sources. But in that sense, maybe there are also employers that think exactly the same. Oh, my employees will not be bothered by it. I can just do whatever I want or interpret the law, bend it a bit here and there. So this is also a problem of the culture of companies as well. And I think to add again to what my colleague said, implementing all these tools really need to be done perfectly, exactly as the law tells these data controllers to do it. So starting from having the data protection impact assessment, from having a privacy notice that informs the employees about how you do it, why you do it, the purpose, to explain everything in great detail so they are also aware. We don't want the cases where employees don't even know they had some monitoring software on their computers and found out, 2 years later. So this is very important. And in this sense, to give you an example, in the Netherlands, it's already mandatory to have a data protection impact assessment if you plan to monitor your employees. So at national level, this was adopted, and I think it's a very good measure. Of course, more can be added to it, but it's a preliminary step, and I think it's a very good one.
Yeah, sure.
I just want to add a very short story from Greece. It's one of the recent decisions of the Greek DPA about a teacher of foreign languages in the afternoon. So there was like 5 or 6 teachers teaching to children English or French or German languages, and the owner of this afternoon school used to jump in on each and every one of those calls with the students in the Zoom platform just to ensure the quality of the service provided. So at some point, one of the teachers, after having many discussions with the owner, said that that's enough, I'm going to the Data Protection Authority. And it made me wonder, it was just 1 out of 5 or 6 teachers. So the rest of them were not annoyed by it. They were fine by it. So I think it's very important for trade unions, going back to this one, that we educate the members and the workers about what is going on with workplace monitoring and workplace surveillance, because I think in many cases employees do not understand that their rights might be infringed.
Yes, you also want to...
Yeah, I would just want to confirm that. I think there's a very simple comparison. If we would have somebody following us around our work, when we do our work, and constantly look over our shoulder, write down everything I do, how quickly I type, if I'm looking a bit concerned and not happy, my voice is not the right timbre, that I speak a bit, I don't know, I'm not super motivated, or I look, my eyes are moving over there constantly rather than on my screen. If somebody did that, how long do you think you would support that? 1 day? I mean, if it's your supervisor, yeah? How long would you put up with that he's following you around everywhere, looking at everything you do, writing down everything, and then also noting down, but Larisa, she's not doing that, okay? And I don't know. How long would you support that? I mean, a day, a week, a month, before you say, sorry, I mean, if I have any choice, I'm going to quit this company. I'm not going to work for you guys, if that's how you treat me. And that's exactly what's happening. The only reason that people put up with this is because they don't see it. Because all what I just said is happening. All that is already being deployed. Sentiment analysis, analyzing my voice, if I used all the right phrases when I was talking with you, because I have prompts showing up on my screen that when I talk to you, I should say, "Oh, how are you doing today? And do you like us?" So I have all this, and that's what people are getting. This is reality what we have in the workplace. So the problem is people don't see the surveillance, and not only is it illegal, but also there's no protest because they can't see it. So if we want the political protest against that, we need to make it visible. Mm-hmm. And yes, education is part of that.
Just a short remark, though, even education was a part of this during COVID. I mean, there are many universities who asked also the students to open up their camera, showing the whole house, recording what they do. I mean, it's been normalized in a way, and it's been challenged also in the Netherlands. I remember the cases, but then what is the limit of ensuring everyone is treated the same, but at the same time ensuring in a way that everyone is surveilled? So it's even ourselves, if we normalize it, how do we expect others not to, is another thing. But before asking your final remarks and also comments on how to balance again this workplace justice and how to base this rights somehow on the GDPR, benefit from the GDPR, or where should we go from there? Do we need further regulations? Do we need more prohibitions in a way? But before coming to that, I want to open the floor for questions, because it's nice that we hear your voice, we hear your questions first. Hope you have some. Great.
Good morning. It's not a question, it's an observation, a remark towards Mrs. King. You mentioned that not a lot of DPAs, or maybe, very small part of DPAs are acting towards Office 365, etc. I think one of the reasons is because they all use it. And what is the alternative? And if there's an alternative, what are the costs? In public, I'm a DPO in public sector, so for us it's really difficult. And if we do have more budgets or much means, then where will we find the people? Because in Belgium, I don't know how it is in other countries, but in Belgium it's really hard to find ICT people and information security officers, etc. So I think the problem is bigger than just that, and I'm still waiting for Europe to again come with an alternative. I know that a few years ago there was this mention of it, but now it's not anymore. I hope the differences now in the political world and with what everything is happening in the geopolitical world, that might be for Europe finally a motivation to look into that more. But then still, as I said, if there's an alternative, then we still need budget persons. So yeah, I don't think it's in practice, it's not so easy. And I really loved also the remark of Larisa, I think, about we should implement the GDPR and do DPIAs, and I fully agree, but in practice it's not easy. So I think there's still a lot of work to be done, but thank you for the interesting discussion.
Thank you. Do you want to go one question answer, or shall we accumulate one more?
I would prefer to answer that, because it makes it easier to answer directly. So you're absolutely right. And in fact, I don't know if you know, but even the Data Protection Office of the European Commission has informed the Commission that they're infringing, using Microsoft 365, their own roles. And what have they done? They've denied it. They said is compliant. So that's the size of the problem. And then we're discussing here if the enforcement is a problem. The problem is a systematic and architectural problem. And my answer to it from a political standpoint would be that we've done too little. And since we are coming to the conclusions, we've done too little just looking at the rules and say, okay, let's make a data protection regulation. We've looked too little at standards and approval of products, because I don't think the real, and I'm an economist, so I have maybe a realistic appreciation how realistic it is to develop another Microsoft, European version of it that is sort of compliant. No, but what I think we could have done and still could do is to see that these products are by design and default designed in a way that there is privacy. And there is co-piloting of, let's say, Works Council, etc., to be able to see this. This is our main problem. It's a design problem of these products. They are by design designed to survey people. And all the people analytics that are being added as modules, you get that for free, right? You can sort of supervise everybody, you can spy on everybody. The companies don't even know what they're buying, but they get it in a package, and it's the setting by default. And that's really where we are totally weak, and we've not seen what's coming, or at least not doing anything on standardization and product approvals that are being put in the market on a massive scale. And that is something that can be done, because the resource problem that you talked about, everybody has that. In enforcement, the unions have a problem. You can't police that because it's already sort of deployed at such a scale. So the only way to do it is to do it ex ante, to do it from the start. And that's also, I think, where some of the political room lies. And then you said, okay, what can we make more rules? So we just, give up and say, oh yeah, but now we have even AI, and even AI is so data hungry, so what, let's weaken GDPR rules. I don't think the answer is that. I think we have a very good set of legal frameworks already, Platform Workers Directive, AI Act, GDPR. They're a bit too complicated to be used also by workers and their representatives. So I think there is definitely room for simplification. I'm not even against this deregulation, but we can improve the rules that are there, and we can use those legal frameworks. But we need to work on other scales as well, and one is standardization.
To also respond quickly to the other remark about DPIAs, also for the rest of the audience, because maybe perhaps, we don't have only DPOs in the room. So indeed, I agree with you that DPIAs in practice, starting a DPIA is a whole different jungle. And that's because you are given the title, we have this project, we have this tool, that's what the DPO gets, and then you need to figure out where the data will be stored. Why? Why do we really want to process it? You need to engage with different stakeholders, and it can take weeks just to understand the exact context, and that makes it super difficult. But that's exactly why I was praising the Netherlands for this, because then you push the companies to actually do this exercise and then see if it's really worth adopting the tool or not. Because in many cases, I also experienced it, when they saw the risks, they realized, well, we don't really want to take on board that kind of risk.
Yes, hello. Many cybersecurity tools are deployed in enterprise, and they can, of course, detect some employees' behaviors. And for example, let's take a pregnant woman who has different behaviors during her three first months. And then our employer can detect some different behaviors during that period, but she did not have informed her employer during that period because she, well, you know what I mean. So what kind of guidelines or recommendations would you give for that kind of surveillance by cybersecurity tools?
Do you want to answer first, Larisa?
No, you can.
Okay. I think, and then that's also going to what Irmak said, is to protect workers, we need strong labor codes, because this is about dismissal protection during maternity leave, etc., is against discrimination. We need to strengthen discrimination rules. That's what we really need. I think it's it's the wrong way around to think you now kind of introducing that through data protection regulation. That's wrong. We should have strong data protection regulation. That's exactly what it is. But that's about protecting your basic rights as a worker, as a woman during maternity leave. So that's where it needs to come from. And yes, of course, one should ask, and that probably Larisa is more competent to answer, what actually is the purpose of surveying you in the first place, because of cybersecurity as a pregnant woman? What exactly would be the behavior they're picking up that then is sort of suspicious behavior? That is very questionable what that tool does in that case. That's, I think, more your domain. But I think the basic is labor law.
Yeah, I agree with you. That's why I let you start, actually, because I think it's not necessarily a matter of data protection. It's more tangentially a data protection matter. Indeed, it's about protecting the employee rights there. But in that case, I would really question and would wait for proper documentation as to why that would be needed, because I cannot see how it can be a lawful purpose to. How can it be demonstrated that that will be a lawful purpose to monitor that?
And also, at least today we didn't mention too much, but AI Act has some prohibitions, but limited to like emotional way of surveillance at the workplace. But also some AI Act categorize some of these tools as high risk when it relates to dismissing a worker. Like if you have algorithmic ways of analyzing and using it for dismissing a worker. But still, prohibition side is a bit limited. And in your case, if we had more foreseeable laws in the labor law, it could have been much easier. But again, going through the questioning legitimate aim and so on, you can find answers, indirect answers, but still you would reach the same conclusion, I guess. And any more questions from the floor? I saw you raising hand before, yeah.
Yes. Hi, I'm Kathleen. So I'm maybe a bit exception here because I would represent the employer side. Also, personally, I would be the last who would protect any employer, but I really work for a good company. And I'm globally responsible for our HRIS. So it means that in this system, we have all the employee data and everything. So being on a devil's advocate, so we are in a really tricky situation because we speak about monitoring. These things are built in our tools, and if we speak about power imbalance, it's built in the tool, and the employer depends on those tools. Or if we speak about the data processing, we need to consider all our countries, and we have like 40 countries. So, but I want to just highlight, it's not always easy. I can assure you we want to do it well. That's why I'm here, that's why we are doing a lot. But it's really not easy. So my trouble is like where to start. If you really want to do it well, taking into account the limited resources, taking into account the rights of our employees, how to do it well, because it's really not easy. Mm-hmm. So just wanted to put this remark.
As a quasi experienced social partner, that means we work with the companies in a lot of agreements. I would say I totally understand that companies want to use available technology to improve their processes, that there's lots of stuff that AI and automation can really do, and I'm a huge fan. So don't think just because I defend workers' rights that I don't use AI. I use AI all the time. I think it's great. It can be used for lots of things. But that's exactly it. And you asked what is the compass, to navigate this difficult decision. I think you asked a simple question, for what are you using it for? Are you helping the companies in order to save money on the processes, do better resource deployment? All that's fine. Or are you using it, in fact, to find out who's the least performant, how I'm going to get rid of the person that's already been annoying me for 3 years, but we haven't found the ground to fire that person. And now we're collecting evidence in order to have a dismissal claim or to fight of that, or to how to do mass redundancy by saying, oh, yeah, So I think this is a very simple question that when you're a company developing such tools, and giving it into the hands of lots of companies that actually haven't really thought about it hard, what they're getting, what is the purpose of this? Is the purpose quasi a really good, well-intended one for the people that they should be caring for, their health and safety, their sort of motivation, their staff, or is this one actually that is directed against their employees? And I mean, that goes also for the cybersecurity tools. I mean, if I'm super suspicious of everybody here in this room, and I don't trust you one iota because I'm going to supervise all of you whilst we're speaking, it's not a very healthy system, and that surely is going to backfire, because that tool might be used in whatever, 50% of the cases for the right things, but in the other 50% of the cases, it's exactly used what you don't want it to be used for. And I think this is a responsibility you also have as deployers, and developers, and not just, I mean, the law anyway should put limits. That's why I said it should be in the labor code that you're simply not allowed to use certain tools on employees. That's not constituent and congruent with your labor relationship and your duty of care. And employers are still doing it, and that's very questionable.
Well, that's not the case in past, so
I'm sure you're the good guys. Yeah.
Yeah.
Still, we need to apply certain
And also maybe checking the purpose and the tool itself, because when the tool, like when you have access requests, if you have no way to explain how things work in this monitoring tool, then you would also have another problem. Either the company, that is the third company, third person, would be not explaining how it works because of trade secrets and so on. So you should also keep an eye on whom you are working with and what kind of tool it is another aspect of it, which makes your lives harder and also workers' lives harder when all these tools are protected by trade secrets, I would say. And now, is there any final remark from the audience? Any question? One more, great.
Sorry.
Hello, Midas Nouwens from the Dutch Data Protection Authority. You asked earlier if we know how many complaints we get related to employment situations. We get about 14,000 complaints per year on average. As far as I know, employer or employee situations is not even in the top 5. So we have things like camera doorbells, cookie banners, data transfer to third parties that people don't know about, these type of things. That doesn't mean that it's not an area that we do have some attention for. So at the moment, I think a lot of especially focused on, I work in a team that focuses on algorithms and this type of stuff. So we've been looking at hiring algorithms or kind of like automated assessment during people being hired in the beginning, right? And then a little bit also employment monitoring. But we have 2 people who are working for the sector of the labor sector, and that's not that many people. So it's also a capacity problem. You had some feedback on how long it takes for fines to come out. We're not doing that on purpose. All countries are, of course, different, but one of the things that we struggle with is Dutch administration law. There's a lot of steps and a lot of rights that the data controller also has for due process. So that just means that these things take a long time. So hopefully you can give us some grace for that as well. That's it. Just wanted to give you some facts.
Nice, thank you.
I think it's great we have somebody from the DPA, and that also you explained your situation. And I have full understanding for the efforts, but we probably both could agree, if you're not speaking on record, that it's too little. It's too little, 2 people for the problem that we're facing. And it's too late, even if you say, yeah, it's not, we would like to do more, we'd like to have this high on our agenda, or we'd like to have the fines pass quickly, is for the size of the problem, is a drop in the ocean. And it comes too late. And I still think DPA is our best tool in this toolkit when we're looking at how can we move this topic forward. Because I guess to look on the bright side, what can be done and what do we have? I think we have, in principle, a good legal framework with the GDPR, with the AI Act, with the Platform Workers Directive. We can work with that. Even if there's deregulation coming, we could use it to simplify. We have the DPAs, and yes, the DPAs have been have a mountain of work. But we've seen positive signs, not only in the Dutch DPA, but also, let's say, the Austrians are trying to create a separate department that looks at workplace-related things. We could put some more pressure that there's guidance really put out for data processing in the workplace. That would be extremely helpful, and that it's coordinated in European level, so it's one standard. And it is true that when the DPA says something, we've seen that in Belgium, the HR professionals are taking it up, and the tool developers are coding it into their tools. So guidance from the DPAs on workplace-related stuff would be super important. Reports, you mentioned your numbers, but you also admit that you don't break them down, so we cannot really analyze exactly how many of that is workplace related, what they relate to, what is the basis for the claims, so not all decisions are being published. So this is kind of where we struggle then to analyze the situation of enforcement on the ground. And it would be massively helpful if the DPAs could agree amongst them, there's one standard methodology and we publish all our results in the same way so that academics, researchers and us, we could follow you properly.
Yes. You seem like you want to...
Thank you, Midas, and I appreciate the work of all the DPAs because it's just difficult. But I guess that you have done fantastic work on the report or the guidelines or the consultation that you have done on the AI Act Article 5, in which a lot of that is about emotional recognition, and those things are deployed in the context of employment. You have also, I think, if I'm not mistaken, done a report on algorithmic management. Is that correct? Or in Holland, and similarly in other authorities. But I think that my message, if I can at least advance on this, is that the GDPR is designed to protect all data subjects. All data subjects, including workers. So already that is the foundational level. The second part is that DPAs have realized that they have to talk to other people to treat specific sector-specific cases. And now there is an obligation under the Platform Work Directive, which is very new, that says that DPAs have to coordinate with the labor inspectors at the national level when there are issues about algorithmic management. So already there is a very strong obligation there. We don't know how that's going to really happen in practice, but the Platform Work Directive is meaningful because they have realized within the platform work that there is a huge problem, and hence we have a very strong directive with maybe some caveats, but okay, they are inherited caveats from the GDPR, but we have a directive that it's really sector specific, combining data rights and social labor rights, and giving a role to the enforcement authorities, and I think that's very important. And we have provided some evidence in the Glovo case, Deliveroo in Italy. Trade unions were able to provide technical evidence in reversing engineering the algorithm that was algorithmic managing the worker, and that helped the DPA in Il Garante to provide a decision and a fine. So more and more DPAs will be linked to labor stuff. We need to talk to trade unions because trade unions are in the middle of the workplace. They do have perhaps more access to evidence, although it's going to be difficult to bring the exact papers. But this collaboration is like a cross-fertilization so that DPAs can know more, can decide better, and trade unions can, or workers' representatives, can also know more and know what pushes in GDPR should push.
And since our time is up, can I have your last punchlines, let's say?
I just want to say that there are more and more areas in the workplace that will be affected by the new types of technologies. We did not talk about electronic voting, for example, or platforms where workers will need to provide specific information, etc. And I think a way out of this mess would be enhancing collective bargaining and collective agreements between trade unions and unions of employers that would embed specific data protection provisions to handle these issues. For example, if there is a collective agreement prohibiting the use of monitoring technologies in the workplace, this would also help data protection authorities that are burdened with the overall workload in such cases. So, yeah, that's it from me.
Yeah, I'll try to keep it very short. In my opinion, there's no need for extra laws that would specifically target all these areas. We already have enough layers of laws, I believe. However, what is really, really necessary is to have the right harmonization in place and to make use of the mechanisms that are already there. So, for example, as you were saying, the collective agreements, it's Article 88, through which we can have different legal grounds, or not different legal grounds, but more open legal grounds via the collective agreements that are signed with the trade unions, also through codes of conduct, through different mechanisms that are already there in the GDPR. We don't need new ones, but they are not exploited, they are not used to their full potential. That's my thought.
Thank you.
Okay, my list is tiny bit longer, but I've still tried to make it short. So I think we should strengthen the DPAs. They are best type for the enforcement of the GDPR. And there's lots that can be done. I said a lot of these things. Then the second thing is for the collective dimension, we should, there I agree with my colleague here, we need collective agreements on the AI tools or other tools that are being implemented, best sectoral, not only kind of enterprise level. And we should implement the Article 80, paragraph 2, which would be the obvious one, which allows collective enforcement. And then a wish for the future, which is the biggest problem I see with the new tools being deployed is discrimination. And maybe another panel in the future should be really discussing that, because the highest risk that we face from these tools being deployed is not that they're data hungry and they analyze whatever you do, but the problem is the consequences they draw, and that they will be discriminating. If they find out you're pregnant, you're going to be out. If they found out you're not working as fast as you should, you're out. So the problem is the consequences that are being drawn. And so it's mainly discrimination that I'm worried about. And there, unfortunately, our key is not strong enough. We have very good labor rules, social rules, but we have very weak rules on discrimination. And that's something where we will need stronger rules.
Thank you.
Just to close very quickly, algorithmic management is the trend of the century, if I may, with all the different types of data gathering, whether it's biometric, non-biometric, or even emotional or behavioral. And this is where in which the DPAs and trade unions and everybody needs to be more acquaintance with and know what to do. I hope that all the data rights can be exercised by workers. It's not the case. So starting from that, it could be already a very good move. Thank you.
Thank you so much for your patience and sacrificing a bit more time from your lunchtime, and great speakers we had today. Thank you so much also.
Thank you.